Welcome to our webinar about the Uyghur Forced Labor Prevention Act and what you need to know to stay compliant and on top of your supply chain. This event is organized by the European American Chamber of Commerce, New York. My name is Yvonne Bendinger-Rothschild. I'm the Executive Director of the EACC, and I will be your host and moderator for today's event. Our panel includes Joanne Colonelli, the Center Director of Pharmaceutical Health and Chemical Excellence and Expertise at the U.S. Customs and Border Protection. Joanne leads the CBP Operational Implementation Working Group of the Uyghur Forced Prevention Act and the Special Task Force associated with that. Before that, she served as the Assistant Port Director for Trade Operations at the Port of New York, Newark. She also served as the Assistant Director for Trade Basic Training Academy in Charleston, South Carolina. Arthur Bodek is a partner of Grunfeld, Desiderio, Leibowitz, Silberman, and Kleestadt. Arthur's practice focuses on import and export, trade law, customs law, and other regulatory law as it relates to international trades. His work centers around developing creative strategies to maximize benefits under the free trade agreements and a host of duty-free, reduced due tariffs programs. Our topic today, the Uyghur Forced Labor Prevention Act, or also known as UFLPA, is coming into effect, and alongside of European legislation such as the Lieferkettengesetz in Germany and similar regulations in France and other jurisdictions. And importers and exporters alike will face increased scrutiny with customs officials, both at the US and European entry points. On both sides of the Atlantic, multi-agency forced labor task forces are developing strategies and guidance to help importers on due diligence, documentation requirements, and help manufacturers as well as IM and exporters to continue move products effectively across borders. So let's start at the beginning. Arthur, give us a brief overview of what we're dealing with the UFLPA and what's different than the regulation we had in the past.
Sure. Thanks, Yvonne, and welcome and hello, Joanne. So forced labor as an enforcement area is not a new thing. We've had in the US a statute on the books for close to 100 years under which goods that were imported that were the product wholly or in part of forced labor, wholly or in part, that concept extending to inputs, were prohibited for importation. Just as an interesting historical oddity, until 2016, there was actually an exception in the statute, which people refer to as the consumptive demand exception, which said that if we don't make X in the United States, then it could be brought in, even if made under the most horrendous conditions. That, fortunately, in my view, was written out of the law in 2016. So now any goods that are the product of forced labor are prohibited for import. So traditionally, historically, the way that has been enforced has been through withhold release orders. And basically what those are in a nutshell is when there's a circumstance in which the Customs Commissioner finds reasonably but not conclusively that a certain category of goods are made with forced labor, then he issues a withhold release order, which is an instruction to the ports to detain goods covered by the parameters of the withhold release order until and unless the importer can show that their goods are not covered. That has changed dramatically with the UFLPA or Uyghur Act, which I prefer to say. Some people refer to it as UFLPA. Not a big fan of that reference, but in any event, in response to reports in recent years over labor abuses involving the Uyghur and other populations in the Xinjiang region of China, a separate special statute was passed, signed into law in December of 2021. I should just pause for a moment to note that there had been a prior initiative to pass a similar law in the previous Congress, which didn't make it to the president's desk, but this one did. And the critical provisions took effect June 21st of this year, approximately a month ago. And the centerpiece is the provision that's known as the rebuttable presumption. If people know nothing else about the act, they've heard of the rebuttable presumption, which basically provides that to the extent that goods are made in whole or in part in Xinjiang in China or by an identified entity under the act, they're presumed to be inadmissible under the forced labor statute unless the CBP commissioner grants an exception, which will only be granted if he is satisfied that the importer has demonstrated by clear and convincing evidence, a quite high standard, that the goods were not made with forced labor, that the importer has followed CBP guidance and has fully responded to all CBP inquiries, and even then, if an exception is to be granted, the commissioner has to file a report with Congress. So, in a paragraph, that's the Uyghur Act.
Yeah. And what are some of the products that are affected? I mean, this is super broad. I don't know, Joanne, do you want to talk about that a little bit?
Sure. Well, there are certain high priority commodities that are viewed within the XUAR, the Xinjiang Uyghur Autonomous Region, that we do consider high risk. And those are cotton, polysilicon, and tomatoes. So if any of the goods are made whole or in part of these goods, you really need to be looking at your supply chain to determine if there is any nodes within your supply chain where these goods could be coming in to the finished product. Again, something like tomatoes, if you're bringing in tomato paste, you need to make sure that none of the tomatoes or the seeds that are used in the production come from the Xinjiang region. The same thing with cotton. Historically, over the past, I think January 2021 is when we issued the withhold release order on cotton products from the Xinjiang region, which includes anything that is made with cotton, so a t-shirt, gauze, sheets, anything that has cotton could be made with cotton that's harvested from the Xinjiang region. And of course, also polysilicon. So importers need to be able to keep complete records of their transactions and the supply chain documentation that demonstrates all the entities that are involved with either the manufacture, the manipulation, or the export of a particular product and the country of origin of each of those products. So you really need to know your supply chain if the finished product contains any parts of these goods. And just to add on to what Arthur had mentioned as well, for an exception, not only do you need to follow CBP guidance, but you also have to follow the Forced Labor Enforcement Task Force guidance, which is the strategy that was written for the implementation of the UFLPA. So not only CBP's guidance, but also the FLETF's guidance.
Interesting. I mean, lots of different moving parts, I should say.
Yes.
So the apparel industry has traditionally been, pretty, early on involved in tracking, where things are made. And what's the new normal right now with this new regulation? Joanne, if you want to start, and then Arthur, maybe comment in on that.
Sure. I think the new normal is being able to move further and further back into your supply chain. Many textile and apparel importers that take advantage of various free trade agreements are used to tracking it back to the yarn and in some cases to the fiber. But this, for anything that's coming from this region that may be using cotton, they've got to be actually going back to the cotton bales. at this point to ensure that their goods are not being made with this cotton or any other part of the garment or product. So for instance, a button that's on a shirt, if that is coming from the Xinjiang region, while it may not be listed as a high-risk quantity, you need to be able to understand and articulate to CBP where that's coming from in the supply chain.
So, I mean, that if you have the process in place, you know, the apparel industry in many cases had, that's great. But what if you don't? I mean, this is how does this play out on the ground? You know, I mean, it's like, you know, I just bought these handy, you know, little silicone freezer bags. I mean, and there's so many other things, cosmetics that silicone goes into. How do companies, I mean, they had time, plenty of time to get ready for this, but how does this play out on the ground is what I'm asking myself. And I don't know, Arthur, if you,
Yeah, Arthur, if you want to go ahead.
So it's playing out somewhat tumultuously, I would say. That you know, it is a new normal. You know, it's both new and normal. So you know, some companies are ahead of the curve. You know, some are at the curve, some are behind the curve. And you know, starting you know with apparel, you know, you mentioned that. You know, companies, you know, even highly compliant and socially conscious companies, you know, they would be all over their tier 1 factories and sending people in and interviewing workers and, you know, looking at, you know, wage records and cleanliness and safety and all of the, you know, usual labor concerns. And, you know, they would have some visibility to tier 2 in terms of the fabric. And then, as Joanne said, if they were using a free trade agreement, you know, maybe further back to the yarn, but vis-a-vis the yarn, you know, it would really be just, you know, that where did the yarn come from, as opposed to, you know, eyes on what's going on in the yarn factory. And now the expectation is going back to the bale. You know, it's an understandable expectation. It is the law now, and you know, companies are scrambling. You know, what I've been doing this 35 years, and you know, I thought I knew pretty much all there was to know about making a garment. And what I've learned in responding to a number of WRO detentions for cotton apparel for our clients is that, you know, you could have a shirt, you know, a striped shirt made from one fabric, where you could have 8 yarns. You know, you could have, you know, 2 4-ply yarns, for example, and then each yarn could have, you know, 2 cotton feedstock sources. So, you know, you could have, at the end of the day, you know, 20 different supply chain nodes, if you will, or participants in a particular transaction. And very often, U.S. brands are not, you know, in privity with those earlier tiers. You know, they've been relying on other people, and you know, it's really required you know, it's been a game changer where, you know, companies are now reaching out, making it a condition of sale, and you know, demanding assurances, documentation, etc. That all of this can be demonstrated. And I should also note, just in response to some other things that have been said, you know, we've been talking about China. You know, as Joanne had mentioned, that this law addresses goods that include inputs from the Xinjiang region. So you could have finished articles made in other countries. You could have apparel made, you know, in you know, various other countries in Asia, or theoretically elsewhere, that could be implicated. And while I haven't seen a case, I'm not aware of a case. You know, you could have tomato sauce, to follow that example that was given, you know, made in Italy that has tomato products, or even the seeds that came from Xinjiang. And you know, Xinjiang is a big supplier of tomato products. And you know, although there are the priority areas that are noted in the statute. There's another one that was added by the I'll just call it the Joint Labor Task Force, which added a fourth category at their discretion, just apparel without any further qualification, because there's concern that in the apparel industry, as discrete from the cotton industry, where the concern is over harvesting practices, in the apparel industry, the concern was expressed that some factories participate in, to state it mildly, non-traditional employment practices, where they're hiring from agencies as opposed to from the free market, which, whether it's under the rubric of, poverty alleviation or pairing or, training, etc., which is allegedly utilizes workers that were involuntarily transferred from Xinjiang. So there's really a lot of moving pieces, and importers have to really be able to trace all the way back to the raw inputs, and they also have to take a look at the labor and the intermediate steps to make sure that it's traditional bargained for labor and not solicited through one of these non-traditional means.
Yeah, let's step one step back for a second. International collaboration, and I would like Joanne to start on that. What I think this is also a complete new, circumstance with the Uyghur Act. How you are working with your European colleagues, with other colleagues around the world. Do you want to talk a little bit about that?
Sure. So we're working with our European colleagues as far as they're considering different laws. So we're working with them to say how we developed our law, how we implemented our law. What are some of the good things about the law? What are some of the things that we might have changed in our wording and things like that? We also have an international affairs division in CBP with our attachés in Belgium that work very closely with the embassies there to get the businesses ready. I will admit that our biggest focus has been in Asia and Southeast Asia. So we've done several webinars for the businesses in the Chinese embassies in Malaysia, in Laos, Vietnam. So the push has really been there because I think that's where a lot of the goods, when we're talking about wholly or in part, where they are closest to the Xinjiang region. And it has been noted in the past that exports from the Xinjiang region have gone to those countries. So a lot of our outreach has been there to the businesses for them to understand that this is a stance that the U.S. government has taken against forced labor, and CBP will enforce these laws regarding the bar of these goods coming into the United States, and really what it means to those businesses as far as what is an exception and what types of documents and clear and convincing evidence, as Arthur had said, will have to be given to CBP to prove to our satisfaction that those goods are not made with forced labor.
Yeah, and Arthur, on that note, thank you for that, Joanne. So what are there seemed to be, when we talked about this earlier, a different focus in the EU. EU looks more at the due diligence, and in the US, we're looking more at the reputational risk. Do you want to talk about that a little bit?
Sure. I mean, with the caveat that I'm not a European practitioner, but nor do I play one on TV, but I speak to them, and did a panel in Paris in May with a colleague from France, Germany, and from the European Bank, and there the focus is not, at least currently, is not on the interdiction of merchandise, but viewing forced labor as a corporate due diligence exercise. That companies have to file reports and make certain certifications, and they have to be accurate, and they have to thoroughly research and show that they've performed their due diligence. And my impression, just as someone who reads the news, is that in Europe there's a heightened sensitivity towards false claims. Like, for example, greenwashing. If a company says, my product is environmentally friendly and recycled and doesn't harm the environment, blah, blah, blah. And in fact, that's not true. There's a backlash. The same with respect to forced labor. But in a nutshell, the approach there seems more to be about due diligence and naming and shaming, as distinguished from the current focus on the U.S., which, not to exclude other remedies, but the front and center, the approach is the interdiction of forced labor merchandise.
And in the U.S., Joanne, you mentioned that the goal is really to stop the practice. I mean, that's why. I mean, I don't want to say we're coming down hard on this, but it looks to me that we're coming down harder on this than we have ever before. So at this time, we really mean it. To stop, forced labor, or products, produced with forced labor to come into the U.S.
Yes, and it's really evolved, starting with the withhold release orders. And if you notice, a lot of those withhold release orders were for products within the Xinjiang region, and they were a direct result of the trade advisories that came out from interagency, multi-agency, but was posted on the Department of State website about the things that are going on in the Xinjiang region. So yes, we have definitely, our regulations are in the books as far as stopping and detaining goods that may be made with forced labor. The Uyghur Forced Labor Prevention Act strengthened those enforcement actions and enhanced our already enforcement actions under 19 U.S.C. 1307 as far as goods coming from that region. So yes, there is a big push within CBP to stop those goods before they get into the United States, when they arrive at the United States, and to exclude them from the commerce of the United States. And if we find that there's obvious evasion of the goods, then possible seizure of those goods. And I give this example. If an importer is trying to bring in goods saying they're not made with Xinjiang cotton, and we open up the cartons, look at the cartons, and it's got a big sticker that says cotton made in Xinjiang, well, we might have cause to use our authority to seize those goods at that point.
Should be obvious, no offense, but okay. Getting a little bit more into the technical aspects of this. So what is the government doing to help, what's the government doing to help companies develop processes, workable processes to go back into the supply chain as varied as nuclear reactors to tomato paste? I mean, it can't be, it must be incredible to line all of these products up against the requirements. Joanne, what is your organization doing to help importers or manufacturers, for that matter, to stay on top of this?
Sure, and Yvonne, it's not only the importers and the manufacturers, it's CBP as well. We are in charge of looking at the supply chain for every single good that comes in the United States, not just one product. So we need to make sure that we understand what the supply chain looks like for these goods. A lot of the outreach that we've done over the past month, we've also included the Department of Labor. So the Department of Labor has several different publications that they have that can assist in developing those types of programs with companies, ensuring that they're engaging with their partners as well, different types of audits that can be done, and making sure that importers are educating their own staff and their own staff that's responsible for those supply chains, to ensure that they know what the risk factors are as well. So I think we've been working with importers. Some of our trusted traders have reached out to us. We also have a binding rulings program where an importer can submit a request for a binding ruling on a specific supply chain. So we've got our UFLPA inquiries inbox. So that's UFLPA. I'm so used to saying UFLPA, and I'm trying not to annoy Arthur with my UFLPA. But UFLPA, thank you. UFLPA inquiries at cbp.dhs.gov, and we can get you that full address later. So we're doing what we can to be able to assist the importer in developing those supply chains, but it's really upon the importer. because each supply chain is so different.
Arthur, what are your clients doing to prepare for this?
Other than not sleeping at night, I would say they are asking lots of questions. The biggest recommendation, when people come to me, I tell them the first thing, if you do nothing else, although, honestly, you must do more than this, but if you're going to start with one thing, the answer is, mapping, mapping, mapping. So if you're buying a shirt, you of course, presumably, know where the shirt's being made, know where the fabric's being made, know where the yarn is being made, know where the raw materials for the yarn is being made. We're telling them to do due diligence vis-a-vis the various links in the chain. For example, the fabric supplier, yarn spinner, the cotton provider, the provider of the cotton bale. And, customs in the past has told me, when I've talked about cases that, so much of this information that they act on is available in the public domain if one digs deeply enough. So, we suggest that once you've mapped, you then get online. I mean, start with Google. You may want to go further, but look up these names. Are there news articles about labor concerns raised vis-a-vis a particular supplier or input supplier? There are other there are companies out there that profess to have all kinds of data in terms of relationships and whatnot. So, so I would say number one, mapping, number two, due diligence on the parties that you've mapped. And then number three, I've been suggesting for key relationships to stress test the supply chain, basically to act as though if you were to get a detention tomorrow vis-a-vis supply chain X, how would you fare? And, if you do that exercise and see that there are gaps, better to fill those gaps in advance, or if there's a problem, identify it and, remediate it if possible in advance. So, those I would say are the three most important steps that we've been suggesting to our clients to do.
I want to get back to what information can be shared in a minute, but Joanne, do you want to comment in on, how companies can best prepare for that?
Yeah, I agree. And one of the things that we also look at, if we're looking at a specific supply chain, and in my regular day job, I'm the center director for pharmaceuticals, chemicals, and healthcare devices. So we were looking at shipments of palm oil. And as you know, palm oil can be used in many different things. There's many different grades of palm oil. So we had to go back and research, how is palm oil extracted? How is it clarified? What is food grade besides pharmaceutical grade? So it's a learning process on both sides. I can tell you that much. And looking at it and what we needed to look at for forced labor, where was the risk assessment? It was in the harvesting of the fresh fruit bunches. So as you can probably tell, I'm a New Yorker. I tend to talk a little fast and skip over words. So even just learning to say fresh fruit bunch several times, it takes time to understand it. And then how does that apply to, like Arthur said, map the entire process, know your process, and identify, like you said, those gaps or the risks within that supply chain of where forced labor could be introduced.
Interesting. Arthur, data, what information can be shared, with whom, when, how hard is it really to do the map that you just suggested?
Well, so it's really involved a reorientation and kind of an attitude adjustment on the part of many parties in the supply chain, where, as I said, that traditionally, companies, would go back only so far, and even those involved in free trade agreements, and those who are, at the pinnacle of social consciousness, would be interested in the origin of the yarn, but wouldn't be reaching that far back in the supply chain, to look at the labor practices of the yarn spinner. I mean, it's just not that it's not important, it just really wasn't on the table. So so there's been, as far as information sharing, I think everyone out there, is kind of beginning to get it, that they need to do this. The analogy that I like to give to people who are shocked by this, for those of us who've been doing this long enough, if we go back, 25, 30 years to the quota world for textiles, there would be customs detentions over alleged transshipments, goods made in one country, presented as being a product of another country in order to evade quotas. And, we would go out to the suppliers and ask, for, time records. And back in the day, cutting sewing tickets, which are these little strips of paper, and, you add them up and do the quantities add up? And, people would come back at us and say, are you crazy? Who keeps this stuff and who would share it with anyone? And, we had to convince them that if you want your goods to come in, you're going to have to provide this type of information. And I think that we're a little bit over the curve, over the peak of the curve, but, we've been seeing some of the same thing, where people at first, thought we were crazy, but they're getting it from all sides, from many of their customers, from customs, from their own governments, that they're finally understanding that they have to get this information and they have to share it if a detained shipment is to have any chance of being released.
Yeah, interesting. Not easy. Before we move on to another topic, Joanne, do you want to say a few words about the wholly or in part concept?
Yeah, sure. And this kind of goes back to looking at that supply chain. And as Arthur mentioned, CBP is very good at looking at country of origin as far as where is substantial transformation. What processes are happening in what countries, tariff shift rules for different free trade agreements, but this is going back even further. So wholly or in part concept means that good that shows up at the border, if that is wholly from the Xinjiang region, then that is subject to forced labor. They're subject to the Uyghur Forced Labor Prevention Act. If part of it, if any of the inputs along the supply chain are from the Xinjiang region or from those entities mentioned in the FLETF strategy, then that is also subject to the Uyghur Forced Labor Prevention Act. So wholly or in part means exactly what it says, either that good that is at the border that we're looking at is wholly from the region, or if any part of it from the supply chain, whether it's, as we'll use the tomato paste again, whether it's the tomatoes from the tomato paste, whether it's the cotton in the shirt, or whether it's the polysilicon wafer in the solar panel, any part of that. And again, if you look at those trade advisories, those are the three commodities that were mentioned in the Uyghur Forced Labor Prevention Act. But there are other commodities that are mentioned in some of the trade advisories, such as human hair, footwear, gloves, sugars, stevia. So, make sure that you're looking at those business advisories as well.
Thank you. So groups affiliated to the XUAR, what does that? What do people need to know about that?
Who are you asking?
And Arthur, if you want to take the lead on that, yeah.
Okay, sure. So, basically the statute requires that the task force identify various lists of entities that, are either, outright making goods in the XUAR, or are committed in or are involved in other activities addressed by the statute, such as transporting laborers, resulting in the involuntary provision of labor. And, there are 3 or 4 categories of such parties that the statute requires that be identified. In the first go around, the task force has put out, what I think we all recognize is kind of a first draft or a modest list of impacted companies. I think there are about 50, if I counted correctly. And I think, just by following events, we kind of know there are more than that. And there will be follow-up Federal Register notices periodically, including one rumored to be quite soon, which will add additional parties. So, the impact of that is that the statute bars anything made wholly or in part in Xinjiang or produced by one of these named entities. So being on that list elevates them, elevates those goods made by such a party as being squarely within the crosshairs of the statute.
It's not a safety measure, no? I mean, if you're not on that list, that doesn't mean that you have a free fall.
No.
Far from it. And in fact, just to make one other quick comment, we've had some, interesting discussions with CBP officials in addressing WROs where, any nexus to Xinjiang has been deemed, as a possible red flag. And, I think there can be spirited debate on this, but just to report, what I've seen, we've had situations where, I'll sanitize the facts, where there's been a supply chain where nothing happened in China, and there are documents, supporting every step of the chain. And reading between the lines, our understanding is that one of the links is owned by a company that has or used to have a plant in Xinjiang, even though they don't pop up in this particular transaction. And the party that did pop up in the transaction is, absolutely, legitimately present in this other country and has production records and, is there to be visited, etc. So, so that's a long way of saying not only is the absence of a name from the list not a safe harbor, but sometimes even if you're dealing with a quote unquote, good party, if they're perceived as having a nexus to Xinjiang, we found ourselves kind of, having to push the boulder up the mountain to prove to the CBP reviewer that, there was no commingling from, this non-Xinjiang or even non-Chinese input suppliers inventory with commingled inputs from a related company in Xinjiang.
Interesting. Joanne, do you want to comment in on the high priority sector lists?
Yes, a little bit. And what I want to go back to is explain a little bit of the entity list and how that relates to the Forced Labor Enforcement Task Force. So the Forced Labor Enforcement Task Force is a multi-agency task force that was set up under USMCA. Okay, so under the United States, Mexico, and Canada agreement. They are in charge of the FLETF strategy. So Congress gave them the authority to write it. Now, if you look at the FLETF, the major players on the FLETF, the chairperson is DHS, and then there's Department of Labor, there's USTR, and I believe the Treasury. CBP is an observer of the FLETF. So we have a great deal of input through DHS and developing the strategy, and we were also a big part of some of the importer guidance in the FLETF. But the FLETF strategy is really run by the FLETF. So entities coming on or off that entity list are based on the group, this interagency group, and how they get on and off is being worked out at this point. But I just wanted to make it clear that those are the entities as to how you get on and off the entity list. CBP's targeting is separate than that. So CBP has a very robust targeting program based on intelligence that we receive, not only from our trusted partners, but from received from other governments, from e-allegations, so from NGOs, and we take very, very hard look at that information to determine what's actionable and what's not actionable. So I just wanted to give a little bit of background on how we target it and put the FLETF and the entities kind of in context as to where they come from.
So thank you for that. Requirements of proof, evidence, and documentation. Arthur, do you want to take the lead on that?
Sure. So basically, the way the statute's being interpreted and the way it's reflected, in my view, correctly, in the CBP operational guidance as well in the task force guidance, is that there are really two conceptual ways of responding to a Uyghur Act detention. One possible response is, yes, my goods are wholly or in part, made in Xinjiang, which could mean, if it's tomato sauce, the seeds are from Xinjiang, for example. But that notwithstanding, there was no forced labor. And that's the situation where an exception would be required in order for a shipment to be released. And without reading a long laundry list, the CBP operational guidance is prominently on their website, easy to find. But the expectation is to provide not simply an A to Z document trail, but that there be a system in place with respect to forced labor, that there be a tracking process, that there be a due diligence process, that all of the CBP guidance, that one can demonstrate that all that guidance has been followed, that any inquiries that CBP may pose, for example, based on my handling of WROs, CBP may come back and say, show me how this material got from here to there, or show me payroll records for this this supplier, etc. All of those have to be responded to. So it's quite voluminous. It's not simply an audit trail, but it's demonstrating that there are documented systems that were in place to ensure the rooting out or identification of forced labor, and that all of that was followed and observed. So that's type of response one. Type of response two is that no, my goods are not wholly or in part. They were made completely outside of the Xinjiang supply chain, and not produced by any named entity, and we simply disagree. And there, the requirements are still quite voluminous. One has to have an A to Z audit trail, but one doesn't have to also have the what I'll call the systematized aspects of the guidance in terms of having a system in place, due diligence system, a tracking system, financial, consistent with GAAP, etc. But it just has to be a complete audit trail to show that that it was completely outside of the Xinjiang supply chain. Either way is quite quite a stretch. But if one is taking the position that there was no Xinjiang, then it's a little more modest. And in that case, there's no exception required, because the theory is that it's not really covered by the Act if the importer can demonstrate that it was outside of that supply chain, and therefore the rebuttable presumption wouldn't apply, the clear and convincing evidence standard wouldn't apply, and the reporting to Congress wouldn't apply.
So, I mean, you start out with, providing evidence that you're not, there's no Uyghur related, or the region wasn't touched. Your product hasn't touched the region, and with that, you should have a free flow through customs.
I wouldn't say free flow, but maybe an easier time.
Freer flow.
Yeah. I'm going to weigh in on that a little bit, Yvonne. So yeah. I just want to clarify that if you say that, yes, these goods, there is an input from the Xinjiang region, it's at that point that, and then you would be applying for an exception from the Uyghur Forced Labor Prevention Act, and it's you do have to follow the CBP guidance, but it's the FLETF guidance that rules at this point, and that's listed in the statute. And that guidance deals a lot with due diligence. And there's many papers written out there, due diligence such as third-party audits, such as working and visiting these places where goods are mined or produced. And it's already well written out there that to be able to do any kind of due diligence in this region is almost impossible. So that's the one thing. If you are saying yes, there are goods or inputs in this good from that region, you have to follow the FLETF guidance, which is much longer than the CBP guidance, which is meant to be operational and to complement the FLETF guidance. Again, by clear and convincing evidence, CBP has to determine that there is no forced labor. And at which time, if CBP does determine it, it has to be reported to Congress and publicly disclosed as to what we agreed for, what we granted an exception for. And Arthur's correct. If the importer says, hey, wait a minute, CBP, there's nothing in this good that came from the Xinjiang region, then they just have to prove to us that that supply chain is free of any inputs from the Xinjiang region. And there is one third one, though, Arthur. I will tell you that one. There's a third. If the importer chooses neither to contend the goods, they can export it as well. So that is an option.
I will chime in that you know, if I had to guess, I would guess that might be the most popular option. And you know, the reason I say that, you know, if an importer you know, is unable to, you know, rebut or to demonstrate that there's no Xinjiang, you know, even if in fact, you know, that's the case, but you know, just the evidentiary standard is not met, the importer can expect that every subsequent shipment from that supply chain will be detained. So, you know, if an importer finds themselves in that situation, you know, they know that, you know, if their information is not going to be better on the second shipment, you know, it's almost a guaranteed fail. So they're going to export. And then, you know, also if it's a low value shipment or an unimportant supplier, just, you know, the costs and you know, resources. I mean, you know, without exaggerating, you know, we've had situations where on one style of apparel, you know, we would be, you know, submitting, you know, 600 to 800 pages of documentation. You know, because as I said in that shirt example I gave, there could be 20 parties that touched it. So, you know, it's not for the faint of heart. It's not a small undertaking. So, you know, very often companies will decide to export just, you know, it's just not worth the effort. You know, even if they have no reason to believe that there's a problem.
Interesting. We have a couple of questions from the audience, and I would like to add them real quick. Does the UFLPA contain a de minimis provision? And can U.S. authorities also impose fines? Are U.S. companies liable vis-a-vis victims of forced labor?
I'll take the first one. There is no de minimis.
Okay.
That's it. Can you repeat the second one?
Can U.S. authorities also impose fines? And are U.S. companies liable vis-a-vis the victims of forced labor?
CBP can administer civil penalties regarding any type of fraud that we find evident in the transaction. If there is some kind of recidivism where we find that there are goods within there that the importer has shown that there was forced labor and they continue to try to bring them in. As I mentioned before, there is seizure as well if we find that there is blatant attempt to evade the laws. As far as the importer civilly liable to forced labor, I don't know. I would have to get back to you. I don't even know. That would not be within CBP's jurisdiction.
Yeah, it's a human rights violation. Huh? Can they be taken on for a human rights violation? Arthur?
Yeah, agreeing with all the above, I would just add, you know, and not my area of expertise, but, you know, I've seen just in terms of news headlines, you know, there have been cases I've seen reported where, groups of laborers or public interest groups have sued different suppliers overseas with respect to alleged forced labor abuses. So that's a whole separate question, but it's certainly outside the enforcement of the Uyghur Act.
Interesting, thank you. And we have another question. If there are any industries or sectors that are in focus for imports or export issues, semiconductor, auto, textile, healthcare. I think we addressed that in part, because it's, I mean, if you look at the products, cotton goes kind of everywhere. Silicone is such a broadly used product, but I don't know if you want to add something to that.
Yeah, I mean, I would take a look at the strategy document, which lists some of those high-risk commodities, and also to the 2 trade advisories, which also list additional commodities. And I myself set up a Google alert on any kind of forced labor issues, so that you're kind of reading what's out there and understanding what's out there in open source news and what's being reported on.
Yeah. Joanne, do you want to say a little bit about other future administrative actions?
As far as future administrative actions, we're implementing the law, obviously as of June 21st. Some of our guidance documents may have some updates in the coming months due to some of the best practices we learned. Some clarifications that we want to put into some of that guidance, not necessarily the FLEDF guidance, but obviously the CBP importer guidance. Administratively, our targeting will evolve as we look at different information from across different sectors and industries. So that will be updated. Again, this is we've been in place now a little over a month. So we've got some lessons learned, and in some cases, some of the shipments that we've detained, we're just starting to get some documentation. So again, this is where we intend to work closely and listen to the importing public and pivot as we need to.
Thank you. Arthur, do you want to comment into that?
Yeah, just I would say two quick thoughts. One technical and one kind of philosophical. The technical one is that companies should be aware that one of several major changes in the Uyghur Act approach is that the detention period is only 30 days, and that as a principle, the supporting documentation has to be submitted within that time period. But various CBP officials have confirmed that that time period can be extended. So I think it's very important that companies know, keep an eye on that clock. And, if you think that, you've got a good shot at getting your document package together, but you're not going to make it within 30 days, reach out to CBP and request that extension so that your goods don't inadvertently get excluded. So that's just a technical observation. Then, the philosophical point, it's the last thought I have, subject to any questions, is that, although, in some sense, I guess this is adversarial, the process, in that, Customs CBP is stopping shipments, the importer is claiming that they should be released, and there's back and forth on that. But I think if we take a giant step backwards from, the particulars of a given shipment, I would venture to say, somewhere between 99.9 and 100% of the trade, abhors the concept of, forced labor, particularly that covered by the Uyghur Act. And I think all concerned would be best served if, the problematic goods never get made, and that, any alleged bad actors never get paid to make goods that are inadmissible, as opposed to the goods getting made and, reaching these shores and then getting detained. So, just raises I think room for collaboration on both sides. That I think importers, we've been talking about the new normal. They've got to step up their due diligence programs as compared to say a year ago, and reach further back. And I think that the more information that can be shared, within suitable parameters on both sides, I think would promote the objectives of the statute. Because I think at the end of the day, we're all best served that these goods not get made in the first place, rather than they get made and then come here and get detained. So, I think that there were a lot of voices out there calling for any kind of, and I don't have specific, proposals or criticisms to make at all at this point, but, I think that's kind of the spirit. And, I analogize this, more to CTPAT than to traditional compliance issues. Just like CTPAT is designed to keep terror out of the supply chain, the Uyghur Act is designed to keep forced labor out of the supply chain. And anything that can be done to promote that partnership, I think, furthers the goals and serves the interests of all concerned. So I will end on that uplifting note.
Thank you.
Joanne, your comment on that?
Yes, no, I agree. I've worked with CTPAT and Trust Your Traders as part of the centers. We kind of walk a line between trade facilitation and trade enforcement. So of course, we want to make sure that we are allowing those goods that are free from forced labor to come in, while at the same time enforcing this law. And we work, I work pharmaceuticals, so that's a very secure supply chain. So you can learn a lot from a lot of those commodities as far as what you need to look at and to ensuring that you're hitting all the risk. But I agree, the main purpose of this is to you can go back and forth. If we stop these goods, then there's no work for these individuals, or there's so many different ways that you can look at it. But in the end, I think what they're doing in this region of China is aberrant, as Arthur had said, and I've been very proud to be able to implement this act over the past 6 months, and will continue to be working to enforce it, to make sure these goods don't enter into the United States. So
very good. Thank you for those last final thoughts, I should say. Joanne Colonello, Arthur Bodek, thank you so much for this, for sharing your insights on this with our audience. And a quick reminder, if you are an EACC member and you would like to connect to any of the other participants of the seminar, do reach out. Also, if you want to connect to Joanne or Arthur and with additional questions. So this is a super complex issue, and I'm sure there are questions that, while you're mulling over this program, that come up later. Do reach out to us. We're happy to connect you. We're going to send out a summary of the program along with the upcoming events, and we will upload the recording to our website, so you can listen to it again or share it with some colleagues or companies that you work with. Thank you very much, everyone, and enjoy the rest of your day.